Welcome to today's program titled Equal Pay Day 2023, a look ahead into trends in the equal pay landscape. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Welcome, everyone. We are really looking forward to spending the next hour or so today talking about equal pay issues. We typically launch this webinar and some materials, which we're very excited to share with you today, around what most would call Equal Pay Day, and today is the day that you'll be hearing a lot about equal pay issues, and we are going to be talking about today some of the issues that employers are facing and to hopefully help you along the way. So for those that don't know me, my name is Annette Timon. I'm a partner here at Seyfarth Shaw. I chair our People Analytics Practice Group, and as part of that, we have a very deep pay equity group that focuses on equal pay issues and helping employers from counseling on pay transparency laws to conducting equal pay audits, as well as supporting litigation matters. And so with that, I am joined today by Matt Gagnon, who is also a partner in our Chicago office. He specializes in the defense of class and collective employment litigation. He really does have extensive experience defending and counseling employers with a national presence on a wide range of industries on all aspects of employment law, but he also has a specialized expertise in pay discrimination claims. He's a frequent author and speaker on the topics that we'll be talking about today. So with that, we'll flip it over to our agenda and give you a lay of the land of where we're headed today, just so that you have a sense of what we're going to be talking about. We'll touch on the equal pay landscape. We're going to spend a bit of time talking about wage transparency, including wage range disclosure laws and pay reporting laws that are coming up. Matt's going to talk about equal pay litigation as well as best practices. And, every year when we think about this webinar and how we might assess this, I think we've been holding these webinars for at least 5 years now or so, perhaps even longer. It just sort of is an anchoring place of where we are. So today we're going to focus on a couple of specific areas, understanding that there are broader implications overall. When we look at the next slide, we can touch base on those, right? So we have certainly seen over the course of the years significant amount of advocacy action that has taken place, and that certainly comes from multiple sources. Certainly from employees who are asking questions about pay, customers, grassroots efforts we have seen. We have seen celebrities, sports figures, prominent sports figures, talking about issues with regard to equal pay and really pushing the envelope and demanding equal pay within organizations and businesses. We've also seen shareholder activity. So shareholder actions, putting pressure on boards to conduct, for example, a pay equity study, an equal pay analysis, looking at it. And we've seen, multiple iterations over the course of several years, but really looking for greater and greater transparency from employers on these issues. It looks for, calls for companies to conduct an analysis and then disclose what the company's pay gap might be. Leading from there, we also see a lot of agency action, right? So at the federal level, of course, EEOC and OFCCP are some of the key players in our space anyway. Certainly, we do expect the EEOC to come out with additional pay data collection. I guess it's now been about 3 or 4 years ago now, there was this nationwide, a couple of years worth of pay data collection that was in place for employers. So that's what we refer to as component 2 of the EEO1 report. We do expect, and many practitioners are predicting, that the EEOC will come out and request similar data in the future. We're waiting to hear from the EEOC on that, but certainly they are very focused on equal pay issues as well as OFCCP. So if you are a federal contractor, you are aware that the agency is also very, very focused on equal pay issues, ensuring that companies are doing audits over their practices, and they're examining them when they're conducting their own audits of federal contractors. With that being said, where we're actually seeing the most action right now is in state law changes that we're seeing, as well as litigation. So that's going to be the focus of this particular webinar. We're going to walk through and highlight some of those state law changes that we're seeing, talk about the litigation aspects and where we're seeing case law shape a little bit, and then we'll talk about some best practices overall. So with that, let's flip over to the trend towards pay transparency and talk about that. So there's two, I would say, baseline issues. I mean, several years ago, right, there was a ban on salary history or asking for prior salary history information upon hire or upon, a potential candidate coming through. And that really swept the nation, right? It started in a few states. I think California was the first one who had a formal salary history ban prohibition, and that really swept across many states. So we kind of left that one to the side, and now we're moving to wage range disclosure requirements as well as pay reporting requirements. Those are the two new trends I would say that we're seeing. And with regard to the wage range disclosure requirements, they are currently in the law in 15 jurisdictions, right? So we've listed them off to the side here so that you have a sense of them, and we have a lot more detail that's coming out in the materials that we will share with you following this particular webinar. The second piece, and there's also in 17 jurisdictions, we're seeing pending laws there as well. Some are local, but some are state laws, and those requirements are, really kind of where we're seeing a lot of action. And then the other is pay reporting. So affirmative requests from states that are seeking compensation information concerning your workforce. And those laws we're also seeing an uptick there in 2023. There's 4 jurisdictions that have introduced bills that would collect pay data of some sort from employers proactively. And those include Arizona, Massachusetts, New York, and Vermont are the ones that as of today, we were able to identify for you. So what that means is that, there's just a heightened collection of information that's out there that is both available to agencies and in some instances, applicants and employees. That will lead, we do believe, to litigation, as Matt will talk about towards in a few slides, but that's the trend that we're seeing. So ensuring as an organization that you have an understanding of your own pay practices is really, really critical. So let's go to the next slide and we will talk about California first. So we're going to hit first the pay reporting requirements, and then I'll talk about pay transparency for just a bit. So if you have any employees in California, and you're probably in the midst of it right now, the first report under the new pay reporting requirements in California will be due May 10th. This report has been required for California employers since 2020. This will be the third year, but this is the first year that there is a brand new report that's included in this requirement. So it's I will say, uh, probably one of the more challenging reports to pull together, this new report that we're talking about. There is a new scope. California has broadened the types of employers that are included. So in the past, if you, for example, didn't have a EEO-1 reporting obligation, you didn't have to provide this California report. So this now captures schools, is an example, schools and universities that might have completed an EEO-1, excuse me, that might have completed an IPEDS report as opposed to an EEO-1 report. Those employers will now have to provide this information. It covers employees and what the state is calling labor contractors, which I'll talk about in just a moment. There is new data required. So in addition to W-2 year-end aggregate information, employers will have to report on the mean and median hourly rates. And then this new report is the one that is really causing a lot of I would say difficulty in terms of pulling data, which is that labor contractor report, which I will we'll talk about next. On the next slide, you'll see that the definition is, there's two separate reports. So on May 10th, employers that have at least 100 employees in the country and 1 employee in California, you'll have this reporting obligation. And the first part of it covers the W-2 workers that the employer employs during a selected snapshot period. And that's just a particular payroll period that the employer selects sometime between October 1st of, for this year, it would be of 2022 through December 31st of 2022. That one, I would say most employers have that one down. It's been done for a few years now, but this second report is the labor contractor report. And, labor contractor is, a worker that has performed work for a client employer within the client employer's usual course of business during that snapshot period. So these are workers that are not your employees. It certainly includes, folks that come to you from temporary staffing agencies, but it's not limited to that. And that definition, if you have not seen the definition or the clarification that the state of California recently put out, I would say within the last few weeks, they have expanded or explained that usual course of business they refer to as the regular and customary work of a client employer, and they further define that regular and customary work to be quite expansive. It means work that is performed on a routine basis that is either part of the client employer's customary business or necessary for its preservation and maintenance. It doesn't include those isolated or one-time tasks that workers might perform, but they do provide some examples of, for example, janitorial staff that might be performing nightly cleaning services or general maintenance on a client employer's work site would be deemed to be a worker that is performing services within the client employer's usual course of business. And what does that actually mean? That means that a particular employer is going to have to capture data that they don't currently have, which is year-end W-2 information and hours information, including, the EEO-1 category that particular employee or that worker had. They're employed actually by a temporary staffing agency in a particular example. It's not just temporary staffing agencies, though. It's just anyone who is supplying workers to that client employer that meets this definition. So I will tell you that it is very, very expansive. Working through the requirements for employers in California has been quite challenging because they have to go out to each of their labor contractor partners, collect the information, summarize it, compile it, aggregate it, get it in their own reports. The good news is that, certainly counterparts are working very hard on it. So for example, the staffing agency or contingent workforce industry is very much aware of the requirements, and so are doing their best to put together the information needed. But unfortunately, the state did not give employers a whole lot of time. So we knew it was out there, but we didn't know exactly how they were going to define some of the requirements or set up some of the requirements until I believe it's beginning of February is when they started releasing some information. We actually did a full webinar on California alone and just the requirements there. So if you have workers there and are hearing about this for the first time, please do reach out. The CRD does have really good FAQs that are out there to help you figure out how to come into compliance. But time is moving quickly. We're less than 2 months out from that reporting requirement. There's a fair amount of information to gather and complete. I should have mentioned the one area that the example that the CRD provided was, a company that brings in an accountant to perform an external audit of a fitness company's financial statement. That type of worker would not be included in the definition because that individual is performing services that's an isolated occurrence. So those are kind of the distinctions that the agency is providing. There's a lot of gray in between, right? You might have some that you're not really sure how to deal with, but it's really important to connect with legal counsel on those issues. With that, we'll jump over to Illinois. And Illinois joins California to become the second state, essentially, to require the collection and production of workforce data. Now, this one is different from California, and perhaps for those of you who worked on the EEO1 Component 2 data years ago, that's kind of aggregated by EEO1 report, or excuse me, EEO1 job category. The Illinois pay data report is employee level data. So it's a lot of information that the Illinois Department of Labor has. They are also requiring that the employers proactively verify compliance with certain state and federal laws. There is a template certification form that employers are required to complete. They provide information confirming their compliance with these state and federal laws, as well as sharing information about how often, for example, they conduct their own evaluate compensation within their organization and how they go about setting pay. So those are some areas that you have to think about in terms of responding to these requests. There are rolling deadlines that employers are that the Department of Labor has put out for employers. So you may have already completed your first one last year, your first report last year. I am aware that this is an issue. The Department of Labor is reaching out to employers. They were trying to contact them. They did so using emails. So if you provided your contact information proactively to the Department of Labor as they had asked, then hopefully your information went to the right person. If not, they have been working on trying to identify contact information and sending deadlines to employers. And so we are now seeing, and very recently have seen, the Department of Labor basically telling an employer, hey, you're late with your certification because the deadline passed. Oftentimes those deadlines went to, frankly, I've seen not even company email addresses it's going to, so it creates a bit of stress trying to figure out who received the information. But the Department of Labor has been working with employers on, if the information went to the wrong location or wrong individual, setting new deadlines. But all employers, if you have at least 100 employees in the state of Illinois, you should be aware that you will be providing this information. If you haven't already, it will be happening this year. Under the law, employers have until March of 2024 to complete the certifications. However, because of the way the Department of Labor is doing these rolling deadlines, the deadlines are all expected to happen by this year, the end of this year. So make sure you have that on your radar so that you are in compliance with the requirements. And one of the interesting things, which is very different from certainly other states, is that it does allow current employees to access anonymized data. So there is an affidavit that a current employee can use and send that information directly to the state Department of Labor and request anonymized data for their own job category, and the agency will provide that information, and they will go back. Obviously, for this year, it's only going to be 1 year worth of information, but over time, that information, that the database will get larger. Employers have to provide this information every other year, and employees will have access for up to a 10-year look-back period. So that's going to be a fair amount of data that employees have access to, and it provides them information with regard to others and the pay rate essentially for their job. On the next slide, I just wanted to touch base briefly on record-keeping requirements. I won't spend a lot of time here, but there is a section in the middle there in that I think we tried to put in green there. These record-keeping requirements in Illinois, it requires employers to keep data for 5 years, okay? And what's interesting about this is, you're going to have things like name, address, and occupation and the wages, but it is also requiring employers to keep and maintain dates of hire, dates of promotion, dates of pay increases, and dates any other compensation was provided by the employer for each employee. And certainly we have historically, employers are going to have this somewhere, right? You might have it in a file, you might have paper records, but do you maintain, for example, dates of promotion? That sometimes can be challenging for employers, especially if you change, for example, HRIS systems. Having that historical information for a 5-year period is important to maintain, and it proactively is requiring that information. It's actually data that has to be provided to the agency because the submission information has a little bit more detail than what you might anticipate. So we have seen some employers have a little bit of difficulty with something like a date of promotion or a date of a pay increase in an electronically available format. And then the other thing to point out here is the description of practices that describe or explain the basis of a wage differential. So those are important pieces of data to maintain. If we go on to the next slide, we'll talk about the wage range disclosures for just a moment. And we've done several webinars on this, and we have some excellent resources that are coming to you that provide a lot of detail around these requirements. So just quickly, I will say that with regard to wage range disclosure requirements, there's essentially 3 buckets that we think about. There are some jurisdictions, including California, Colorado, New York. That one will be in place in September of 23. I believe it's the 17th. Washington, the state of Washington, as well as Jersey City and a few counties within New York. The salary ranges will need to be included right on the job posting, and so most of those are already in effect, and employers have been trying to implement those requirements. There is another category that at some point during the application process, typically, sometimes it's after the interview or at the time compensation, an offer with compensation is included, you have to provide the salary range for that particular position. That would be, it's in Connecticut, Nevada, and Rhode Island. And then there's a few other jurisdictions, Maryland, Cincinnati, and Toledo, Ohio, that require it upon reasonable request. So when an employee or an applicant requests that information, the requirements are available. And like I said, the resources that we're providing to you will give you a lot more information about the specific requirements, and we hope that those are helpful to you. But as we go to the next slide, we wanted to talk through these, the best practices with regard to this pay transparency, especially when it comes to posting posting ranges on your job postings or your announcements or notices. You really should be thinking about how to develop a comprehensive strategy. We saw more and more employers, at first saying, okay, I'm going to do what's required of me in these particular counties within New York, or do what's required of me, in California. But over time, it started to feel like it was very difficult for employers to navigate the issues across all of their jurisdictions. And so they started thinking about, should I go with a national approach? And if that's the case, how would I best implement that? So thinking that through is really important, especially when, you recognize that there's more than, almost 20 additional jurisdictions that have pending requirements out there. As an organization, trying to understand how you might deal with it is really important. Consider, your guiding principles. Who's going to provide the information? Who will provide pay ranges? Is it going to be your recruiter? Is it going to be a hiring manager? Just think that through. Consider whether you might provide greater transparency regarding how comp is set as an organization. It's certainly not required, but if you have to provide ranges, you might also want to provide additional information about how you go about setting compensation, because candidates and employees will have a lot of questions once they start seeing ranges that an employer has. Certainly, looking at ranges in each jurisdiction. Do you have employees that are below or above the range? How will you address that? Are you going to post geographic differentials that you might have that do impact the pay ranges? Are you going to provide the full range versus just a more limited range that applies to that specific position? Because there is some tension between certain states and how they would position it. Washington, for example, wants the very bottom to the very top of the range, and yet when you do that, you will have some that believe that the company is trying to hide pay practices. And then think about the language that you're going to be using on your postings and your offer letters. You might consider whether to be more expansive than others. With that, we'll hit the very last slide on pay transparency practices, which is, you're going to have to think about how you're going to address questions from employees. In particular, those employees that might not have pay transparency requirements. And these are the practical and business considerations that go beyond the legal. Coming up with the strategy in responding to questions from employees who see what the range is and might be within the organization for 5 years and realize that they're kind of on the low end. So how might you answer those questions? There's a lot of very legitimate reasons for that. So understanding how you might position that is important, and certainly training is really key as well. You might develop FAQs or talking points for leaders and employees to have a better understanding of what it means, and continue certainly to monitor the pay transparency laws that are coming up. So with that, I'm going to turn it over to Matt, who's going to take us through a few more state implications as well.
All right, thank you, Annette, and thank you all for joining us today. It's my privilege to be able to talk about a subject near and dear to my heart, equal pay litigation. So as Annette mentioned, one of the most significant changes we're seeing to equal pay issues generally are these state law changes. And she went through a lot of the compliance and regulatory changes, but there are also significant changes that impact the burdens and defenses that drive equal pay lawsuits. So let me set the stage for you first, and we can get into some of those changes in more detail. But important to note at the outset that you can bring an equal pay claim under both the Equal Pay Act and Title VII. And they're generally, they're analyzed under the same rubric, but there are some important differences between the two statutes, and those differences can sometimes be outcome determinative. And they can also be important differences in terms of process and procedure. So for example, the Equal Pay Act is a collective action procedure if you have a mass litigation, whereas Title VII is the class action procedure. Another significant difference is some people will argue that the Equal Pay Act does not have an intent requirement, whereas Title VII does. Nothing in this area of the law is completely cut and dry, so there's some debate about that subject, but that's another very important difference to be aware of. So the difference I want to talk about today is the difference in terms of plaintiffs proving their prima facie case. So under both the Equal Pay Act and Title VII under federal laws, and most, if not all, state laws follow the same rubric, they use a burden shifting mechanism for determining liability. So under the Equal Pay Act, first an employee must establish a prima facie case. The burden then shifts to the employer to prove one of the four statutorily enumerated affirmative defenses that are allowed for. And if it can successfully do so, then the burden shifts back to the plaintiff, who must then show or try to show that the employer's reasons for justifying the pay disparity are really just a pretext for discrimination. So quick side note here, although that's the way that most courts will articulate the burden of proof under the Equal Pay Act, this is another one of those issues that is currently under debate and is being vigorously litigated in several jurisdictions, even just the basics of what the burden shifting mechanism is. But under the usual rubric under the EPA, the Equal Pay Act, in order to establish a prima facie case, the employee must show first that they were paid less than one or more comparator employees of the opposite sex. Second, that there actually was a wage disparity between the plaintiff and the alleged comparator. And third, that they performed equal work requiring equal skill, effort, and responsibility, and that they shared similar working conditions. Oh, thank you. So that is the first change I want to talk about today, because in some states, California and Illinois being two prominent examples, and also New York, there were some statutory changes made to the law that changed the language from equal work to substantially similar work. So as an example, in California, under the revised California Fair Pay Act, the standard that employees must meet now is that employees do substantially similar work when viewed as a composite of skill, effort, and responsibility, and performed under similar working conditions. That law, I believe, was passed in 2015 or 2016. It's been on the books for quite some time. And ever since it was passed, the question has arisen, how, if at all, will this impact equal pay litigation? There are certainly some who will argue that it lowers the standard for a plaintiff's burden of proof, and there are others that argue the opposite. Let's take a look at what the courts have said. Let's go to the next slide, please. The early decisions on this have been, I would say, a bit surprising to some. First of all, there are still a surprisingly few cases out there that really touch on this in a big way. And the one case that happens to be most directly and substantially on point on this issue has said that there is essentially no difference between those two formulations at all. So no difference between equal work and substantially similar work. But we'll talk about that in a second. First, let's talk about the other side of the coin. Let's talk about people who, or a case that might support the argument that there is a difference in the language, and also what are the implications of that. And that is a case that was brought against Google in California. In that case, there were 4 named plaintiffs who brought a very large class action against the company, alleging that it had systematically underpaid women employees compared to men performing substantially similar work. One of the key planks of their theory was that the company had a policy of setting starting salary that included consideration of an employer's prior salary, an employee's prior salary. And so plaintiffs allege that as a result of this policy, female employees received a lower starting salary than men for the same position, and then that difference compounded over time because raises were a percentage of current pay, and so the problem just got worse over time, according to plaintiffs. This issue came up in the matter of class certification, and so plaintiffs had argued that because the company had classified its employees by job code for purposes of setting compensation, it should be possible to compare the employees who all have the same job code, and therefore class certification is an appropriate device. Google argued that even if employees shared the same job code, they were not necessarily performing substantially equal work because they worked across many different domains and product areas, et cetera. But the key point is that the court disagreed and specifically pointed to the substantially similar standard. And it said that it does not require that jobs be identical or require exactly the same duties. Remember, at the class certification stage, the court said at the class certification stage, it was not enough that plaintiffs and Google had proffered common evidence to argue their positions directly contrary to each other. That it was enough that they had articulated positions directly contrary to each other because they had relied on, nevertheless, on common proof in the sense that both sides based their arguments largely on expert opinion that was an analysis of data, job data and compensation data. So that's one example of how one could interpret this change in the state law. Quick side note on that, because I find it interesting. There's actually another change to that state law that is on the affirmative defense side. So we've been talking about the plaintiff's burden under the to articulate a prima facie case. There are some changes that were also made on the affirmative defense side. One of which is that if a company wants to rely on what we call the factor other than sex defense, under the California law, the statute now says, the language says, it must be job related and consistent with business necessity. And the employer in that case latched onto that language and said, well, we have a due process right to defend ourselves and to use every available defense. And there would be no way on a class-wide basis to establish that defense under this new business necessity rubric. The court did not buy that argument and said that although, of course, Google would have a right to assert its affirmative defenses, it was comfortable that it could do so on a class-wide basis, primarily looking at data and statistics. The more surprising decision that came out did address this issue much more directly, and that's a case called PAC v. GitHub, and it's in California, but it's an unpublished decision. And there the court essentially held that although the language is different, the new substantially similar standard was actually meant to realign California law with the federal standard. So brief background on that case, former Associate General Counsel alleged she was underpaid compared to her boss, the General Counsel, and another female comparator in a law-related field. And the court had to consider whether those two comparators in fact performed substantially similar work. And the court conducted a rather extensive review of the history of the law and the textual changes and the changes that were made, and eventually held that those changes did not materially alter the definition of equal work or the analysis of that issue reflected in prior state and federal cases. So it's a surprising result by some, but that is what I would consider the case that is most directly on point on this issue. Now, there's another case out there, a more recent case, and it's called Edelman versus New York Langone Health System. And that does show that even though there is a vigorous debate, apparently, as to whether some of these changes, like the equal work versus substantially similar rubric, will have any impact on equal pay litigation, there are some changes to the law that simply cannot be ignored. In that case, what was at issue was the use of prior salary history. And because now under New York, the new changes to the law have outlawed the use of prior salary history to set starting salary, the court in that case readily simply said that you can no longer base an affirmative defense on that basis either. So although we are still in the midst of vigorous debate on all of this, and we don't know where it's going to land because there have been so few decisions, we can already see that it's going to take a while to sort all this out. There are some very subtle differences between the different state laws and the federal laws, and even in between different federal laws like Title VII versus the Equal Pay Act and the state law analogs. And so I think it's a very exciting and interesting time to be studying equal pay litigation because all of these issues are now completely in flux. All right, Let's switch to next slide. All right, now this is another trend that we're seeing in equal pay litigation, and that's how do you even measure a pay disparity? So, for example, as part of the prima facie case, we noted that you have to identify a comparator, but not just that, you have to identify a wage disparity. You have to establish that comparator was paid more than you in order to establish your prima facie case. Seems actually pretty easy. In a lot of cases, it is. But sometimes it's not. And one dispute out there that has been contested among the different jurisdictions is whether a court can find a wage disparity based on differences in base salary or wage rate alone, or whether it must also take into account and compare total compensation, including all bonuses, commissions, benefits, and other things. And I'll just take a note here to say that one of the reasons we spend so much time and effort studying equal pay litigation is that the lessons that you can learn from the results of those cases, from litigating those cases, can be directly applicable to a company's attempts to mitigate the risk of equal pay lawsuits and to bring itself into compliance. And I think this is a question that many employers have had. What are we looking at when we're trying to find a wage disparity? Is it total compensation? Is it just baseline salary? You know, what is it? And so, unfortunately, it is a bit in flux, although I do think that the courts seem to be coalescing around the idea that it is really about rates as opposed to total compensation. So I'll just give you a few example cases to illustrate the trend. In Weiler versus Kent State University, this had to do with the head coach of a university's field hockey team. She alleged that she was paid less than her male counterparts, other coaches at the university. But her claim was based on the fact that other coaches earned a total or higher total compensation, which was the sum of their pay, performance bonuses, and crucially, camp income, sports camp income. And so the court first held that the proper inquiry now under the Sixth Circuit is that it is about rates of pay and not total compensation. And so in this case, the court held that that would include the coach's base salaries and their performance bonus rates, not necessarily what the bonus was, but the rate, because those are components of compensation that are set by the university. The employer had control over those aspects of it. Camp income, on the other hand, coaches had no obligation to run a camp, and the compensation earned from that varied depending on factors over which the university had no control whatsoever. And so the court held that that should be excluded from that analysis. Another example here is Sempowich versus Tactile Systems Technology. And in that case, a regional sales manager alleged she was paid less when comparing base salaries. This is a counter example, because the court in that case held that even though her base salary was less, she was actually paid more than her comparator when comparing total compensation, meaning base salary plus commissions. And the court looked actually to the EEOC regulations regarding wages to come to that conclusion. But the key development this year is that the Fourth Circuit reversed that decision and held that now, what you need to do is you need to look at wage rates, and reinterpreted the EEOC regulations that the district court had relied on. And this is a case where the EEOC has taken an interest in this, and this is actually the case in a few of these issues I'm talking about today, where I mentioned they're in flux. The EEOC has a great interest in attempting to control the flow of the law, or actually just put its stamp on the law. This is one of those cases they filed an amicus brief, and the Fourth Circuit agreed with their interpretation. Okay. We have this other one here. Yes, the very high-profile women's soccer case. The gist of that one is just that it's not just total compensation that can be a problem. It is also what counts as compensation at all. How do you compare two very different systems of compensation? In that case, the employer argued that when compared on a cumulative and average per game basis, the facts showed that the women's team players were paid more in total compensation than the men's team players. And that the women's team players had focused on bonuses, but that ignored the other benefits provided by their compensation arrangement. And that was all by a collective bargaining agreement. And it includes some guaranteed annual salaries, severance pay, some other things that the male players did not receive. And so the court held that it was not so easy to just compare bonuses or other rates of compensation. When you factored in all of the different elements that went into the collective bargaining agreement, it becomes a very difficult question to answer whether or not there is a wage disparity. All right, let's go to the next slide. Okay, now we're going to move from the employee's burden to establish a prima facie case onto an employer's burden to establish an affirmative defense. And so the law recognizes 4 affirmative defenses: a seniority system, a merit system, a system which measures earnings by quantity or quality of production, or a differential based on any other factor than sex. And it's this last one, this catch-all affirmative defense, that the so-called factor other than sex defense, that is by far the most frequently litigated in equal pay litigation. Employers go so far, even when they have a seniority system or a merit system defense, they often couch it in terms of the factor other than sex defense. So it is the driver of defending against an equal pay lawsuit. There are many, many issues because it was a catch-all factor. It's meant to capture many things that might justify a wage disparity, and the sky is the limit in terms of what those might be out there in the American workforce. We'll talk about a few of them today. So as an example, employers will often point to market forces and economic considerations as the reason for a pay disparity. So generally speaking, that's fine, provided that the consequences of these economic considerations are applied in an even and gender neutral way. But, and this is one of those lessons learned, what we consistently find in the case law is that you need proper documentation and consistent application of these policies. So let's give an example of that. So, for example, economic concerns, such as competitive pressures to attract top talent, or financial difficulties and corporate cutbacks. Those might be reasons an employer might rely on to justify a wage disparity. So let me give you an example of a case here where an employer had a practice of paying physicians based on the market value range of their medical specialty, not uncommon in the physician world. Court held that was a legitimate factor other than sex, because and even though the differences among the specialties alone did not even account for the entire salary difference. And that was because each physician was compensated within a range associated with their medical specialty, but also different levels of experience. But critically, the employer was able to come forward with the proof, the documentation, the evidence, contemporaneous documentation that showed that this was the reason for hiring one person at one rate and the other at another. Let's go to the next slide, please. Yeah, thank you. All right, let's jump ahead a bit here. So another factor other than sex that you commonly see is compensation systems. So employers will argue that that the reason for a pay disparity is because one employee sits somewhere differently within the compensation hierarchy than another employee. Very common. That's if you have a graded or stepped or banded compensation system. So an example of that is this Niekamp case. There, a female investigator in the state's prosecution unit alleged that she was underpaid compared to her male predecessor in the same role, obviously comparable work. The court found in favor of the employer, though, because the employer was able to show and demonstrate that the plaintiff's pay was set by the state's Office of Administration's Uniform Classification and Pay System. And that system established salaries for each position and set initial pay rates based on a number of factors like qualifications and permanent position-related factors, working conditions, physical location of the work, recruitment and staffing needs even. And plaintiff had arguments that she should have been paid more because she believed she had more transferable experience, but the court level set it to the compensation system itself and said, if this is a clearly communicated and consistently applied and followed system, and you have the documentation to back that up and the data to back that up, then that is a legitimate factor other than sex, and it held in the employer's favor. So a danger zone with respect to these types of systems, however, is the amount of discretion that individual managers have in setting pay within a banded range, or even allowing some managers to bypass the system entirely. I don't know if it's often the case, but it's definitely a significant amount of times that discretion will mean that an employer is not going to get summary judgment on their claim, on their defense. And the reason is that because unless you have proper documentation, again, to show that there was some rationale behind the discretion, the court can still find that, well, the person was placed at one level of the pay band versus another level due to discrimination. And if you don't have any documentation to back up why that decision was made at the time, you can find yourself in trouble even though you have one of these banded compensation systems. So we have a few example cases here on this, and they make that point. This Moon Area School District school case, it was 9 male public school teachers alleged that they were paid less than similarly situated female teachers in the same school district. Employer looked to their stepwise compensation system as their defense, which was in fact determined by a collective bargaining agreement. And although the employer school district was able to show with respect to each comparator that there were various reasons why those comparators may have been hired above step, the court could not say at the summary judgment stage that any of those proffered reasons actually justified that wage disparity, again, because there wasn't the proof to back it up. Okay. No mistakes. That's a good one. So although a mistake, putting somebody in the wrong banded category due to a simple clerical error is certainly gender neutral. But the courts have held that nevertheless, if that mistake cannot support an affirmative defense under the Equal Pay Act, because it cannot be job related, which is a requirement in many jurisdictions for factor other than sex affirmative defense. Okay, let's go to the next slide, please. Okay, now what can we do? I'm supposed to give a CLE code here. Everyone, the CLE code is SS4898. I'll repeat that. CLE code is SS, as in Seyfarth Shaw, 4898. All right, now we're going to talk a little bit more about best practices. And so for me, lessons learned from litigation. So I've mentioned it a few times already, but having that proper documentation and data to support what an employer is now claiming is a defense to an equal pay lawsuit, that they were set within a particular band due to levels of experience or expertise or some other intangible factor that they brought, that has to be documented. If we have contemporaneous documentation to back that up, that can go a long way to defending against one of these lawsuits. Or data, especially these things can be very data driven. And so if it's years of experience, for example, that can be put into, that does exist somewhere. Keep track of that data. It will be invaluable for defending against an equal pay lawsuit. The other reason why it's so important is that it's another trend in equal pay litigation for plaintiffs to argue that even though there's this robust system, there's a merit system, there's whatever it is tainted by discrimination. So the factors that go into that system are themselves the result of discrimination, and that invalidates the use of that compensation system or program as an affirmative defense. So another reason why documentation and data is critical. Let's go to the next slide, please. All right, along with documentation and data is clear communication and consistent application of these programs. So for example, there are, I mentioned earlier, not just the factor other than sex defense, there is the merit defense, the seniority defense, et cetera. But it is critical that those systems be clearly communicated. So for example, in one recent case, an employee in a university's IT department alleged that she had been paid less than a male comparator. The employer argued that the comparator had started at a higher salary because he had previously worked for the university, and that the difference in pay based on those different starting salaries grew over time due to the employer's merit ranking system. And the court was persuaded by that defense because the plaintiff's poor performance over time had been consistently documented and communicated to the plaintiff. And that was enough to support that defense. On the contrary, this other case, Brunarski case, that's just that the court held there that the merit system in use had vague criteria that were inconsistently applied and therefore held that could not justify a wage disparity. All right, thank you very much for that. And Annette, I'll turn it back over to you for other best practices.
Okay, fantastic. So as we wrap up, we wanted to talk about some other best practices that we're seeing, certainly as employers are navigating, we hope you don't get to litigation, right? So Matt's, providing information about what courts are finding, but, looking at how you might avoid it are some of the areas that we wanted to spend the last part of our conversation on. One is to design a comprehensive comp structure and philosophy. Where are you as an organization with regard to, for example, the market? Are you going to be leading the market or lagging the market? Looking at your pay ranges, are they consistent? Do they still make sense in light of, hiring practices and what you're seeing? Are you going to have geographic pay differentials? Do those still make sense in this post-COVID world where we are seeing a lot more remote work? And how does that implicate, your organization? Certainly, prior experience is a critical factor that we see for many employers, and Matt touched on tracking that as a data point. That is another area that's really important. But some employers say, prior experience doesn't factor into my compensation strategy. As long as I've got people at this level, then I don't need to take into account necessarily prior experience. So it may not factor in. It is really important to have an effective job structure. And by that, I'm talking about, what are the experience levels at an organization? What's the scope of responsibility that you might have? Do you have career tracks within your organization? So that's a little bit different than the compensation structure. This is more about jobs and how you are placing individuals in particular roles within your organization that typically goes beyond a job title. Defining and sharing how the company is going to set salary at various stages. So really taking a hard look at your starting pay philosophy and how you're going to handle that. Promotional increases is another big area where employers really should take a closer look at how they do evaluate pay when someone gets promoted from within the organization as opposed to somebody moving into that role and being hired externally. Sometimes companies have pay practices that could lead to pay inequities as a result. If somebody moves departments into a higher paying group legitimately based on comp or a lower paying group, how will you address those issues when you have employees that move between various departments? On the next slide, we would always recommend that you pressure test your job architecture, compensation strategy, and the factors that you believe control pay or factor into pay by doing regular, proactive attorney-client privileged assessments of your compensation practices. If you do see disparities in pay, certainly those need to be addressed. But oftentimes what happens is that those analyses do reveal compensation practices that you might want to revisit, and those take a little bit more time to undo, but understanding the reasons why you're seeing pay differentials really may help to uncover some practices that were inadvertently leading to or unintentionally leading to unexplained pay differences. We certainly recommend that you establish interim methods to review comp. Looking, for example, at peer equity at the time of hire, at the time of promotion, using tools like compa ratios, looking at merit raises, bonus payments at the time that they're made, to evaluate compensation outside of that regular, company-wide, for example, analysis. And, one of the things I want to leave you with today is to think about that data gap. So you're going to hear a lot in this week and beyond about the pay gap. We would also encourage you to think about the data gap. Are there areas within your organization that you are not capturing data in a way that you can reproduce the results you need to within your organization? A key one of that is relevant prior experience that you're using. You are making compensation decisions on those bases, and oftentimes in compensation analyses, we see that information is no longer available or we lose that information as time passes. So it's really important to track that information. Finally, the last slide, just in closing, we thank you so much for attending. We are sharing 4 new resources which will be available later today. It is our 50-state survey that goes over many of the laws that we've talked about here. We've also added a compendium just on wage range disclosures and providing more detail there. Matt put together a fantastic equal pay litigation resource, and we're also sharing our global desktop reference so that you have these materials and resources. Again, we thank you for participating today.
Thank you to our presenters. This concludes today's webinar. Thank you for attending.